In December 1990, John Gotti, Salvatore Gravano, Frank Locascio, and Thomas Gabino were arrested and arraigned upon an indictment which charged some or all of them with racketeering, murder, obstruction of justice, racketeering conspiracy, conspiracy to murder, illegal gambling, obstruction of justice, and other crimes. One can say in his day, Gotti was considered the real mafia boss. However, in October 1993, a federal appeals court upheld the conviction of John Gotti. He was sentenced to a life prison term for murder and racketeering. Unfortunately, maybe fortunately for some, Gotti died on June 10th, 2002. Now, although Gotti was a man, the government took him down. The government brought the case against Gotti under the Criminal Rico, which is the Racketeer Influence and Corruption Organizations Act. But did you know that an individual or business or group can sue and seek remedies for damages inflicted by racketeering activities? Now, of course, they'd have to establish the prima facie elements. And that's what we are going to talk about today: federal civil RICO litigation. And of course, to help me demonstrate this, we're going to look at case law. So let's get started. A civil RICO claim is rooted in the Racketeer Influence and Corrupt Organizations Act, a federal law designed to combat organized crime and corruption. It empowers individuals or businesses to seek legal remedies for damages inflicted by racketeering activities. But before we get started, let me point out a key difference between a civil RICO and a criminal RICO. If a plaintiff establishes a civil RICO claim, he or she will be awarded monetary damages. If a prosecutor establishes a criminal RICO claim, the defendant goes to jail. So let's look at National Organization for Women, Inc. versus Scheidler. The National Organization for Women, known as N.O.W., sued a coalition of anti-abortion groups called the Pro-Life Action Network Plan under the Racketeer Influence and Corrupt Organizations Act. Now alleged that Scheidler and other anti-abortion protesters were members in a nationwide conspiracy to obstruct women's access to abortion clinics through a pattern of racketeering activity, including the actual or implied threat of violence. Now alleged defendants violated the RICO sections 1962A, C, and D. And for the purposes of this video, we're going to look at these sections. Section 1962A states, "It shall be unlawful for any person who has received any income derived, directly or indirectly, from a pattern of racketeering activity to use or invest, directly or indirectly, any part of such income or the proceeds of such income in acquisition of any interest in or the establishment or operation of any enterprise which is engaged in or the activities of which affect interstate or foreign commerce." Now, I know that was a mouthful, but we're going to break it down as we move ahead, particularly when we address the prima facie elements. Section 1962 says, It shall be unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises affairs through a pattern of racketeering activity or collection of unlawful debt. And Section 1962D says it shall be unlawful for any person to conspire to violate any of the provisions of subsection A, B, or C of this section. So let's look at the Civil Rico prima facie elements. And I'm going to personalize each element to the instant case. The first element is enterprise. Now needs to show the existence of a RICO enterprise. This could be an individual, partnership, corporation, association, or any other legal entity, and an union or group of individuals associated in fact, although not a legal entity. The enterprise must be an ongoing organization with a common purpose. Well, what entity readily comes to mind here? Scheidler and the Pro-Life Action Network or Plan now must demonstrate a pattern of racketeering activity involving at least two or more predicate acts. The acts must have occurred within a specified time frame within 10 years of each other. Fraud, obstruction, extortion, embezzlement, threats, bribery, conspiracy. For a more exhaustive list of predicate acts, you want to look at 18 U.S.C. 1961. Now let's continue with the prima facie elements. The third element is causation. Now must demonstrate a direct causal relationship between the defendant's participation in the enterprise and their injury. Now must show that the defendant's racketeering activity was a proximate cause of their harm. Now remember, now is arguing that plan is interfering with their members' access to the clinics through conspiratorial acts and threats. The fourth element is injury. Now must prove that as a result of the RICO violation, they suffered an injury to their business or property. The fifth element is now must establish that their members have standing to bring a RICO claim. This means now must show that a direct relationship exists between their injury and the defendant's conduct that caused the injury. The district court dismissed Now's case pursuant to the infamous 12B motion to dismiss for failure to state a claim. The court held that the voluntary contributions to defendant organization are not proceeds of racketeering and that a racketeering enterprise must have an economic motive. Now, I don't want to give it away, but Plaintiff Pro Se closely scrutinized the motion to dismiss that tends to deflect from the real issues. You'll see what I mean later on. At any rate, N.O.W was unable to demonstrate that a racketeering enterprise must have an economic motive. So N.O.W appealed to the appellate court. The Court of Appeals affirmed the district court. Then plaintiff N.O.W filed a writ of certiorari to the United States Supreme Court. The Supreme Court granted N.O.W's petition in part to consider whether RICO sections 1962C and D require proof that either a racketeering enterprise or the predicate acts of racketeering were motivated by an economic purpose. In other words, the Supreme Court asked, does RICO require that an organization to be defined as a racketeering enterprise must be acting in pursuit of an economic motive? Great question. The Supreme Court held that organizations without an economic motive can detrimentally affect interstate or foreign commerce, satisfying the RICO definition of a racketeering enterprise. An enterprise does not have to be an economic organization or a principally criminal organization to trigger the RICO Act. Consequently, the court reversed the appeals court decision, which allowed the original case to proceed. Now, since 1994, this case has been before the Supreme Court multiple times. And what I'm going to do is leave a link where you can literally read the timelines of how often this case has been before the United States Supreme Court. And you'll get like a little synopsis of what happened when it went before the Supreme Court. Another feature of RICO, Civil Rico, I want you to know about is that the law allows for the recovery of treble damages. In other words, a RICO plaintiff can seek compensation worth 3 times the extent of their actual financial losses. That's important to know. I trust this video was helpful to you. I'm Advocate Lucinda, and we will see you next time. Take care.